The Constitution of South Africa is the supreme law in South Africa. This means that the Constitution is the highest law of the land. In this video, we will explain what the Constitution is, the characteristics of the Constitution, and why the Constitution is important. Welcome back to Public Administration 101. Proudly brought to you by Kano Consultants. For professional advice you can trust. As indicated, in this video, we will explain what the Constitution is, the various chapters of the South African Constitution. We will also discuss the characteristics of the Constitution, as well as the benefits of the Constitution. We will then conclude on the importance of the Constitution. Now, let's get into today's video by first defining what a constitution is. The Constitution is a concept that sets out the basic principles to be used when governing the country. The Constitution is also considered the highest law of the country. It further describes the major institutions of the state and lays down their respective powers and mutual relationships. In the South African context, the Constitution of South Africa is the supreme law of the Republic. The current constitution, which is South Africa's fifth constitution, was drawn up by the first democratically elected parliament, which was elected in the 1994 South African general election. It was approved by the Constitutional Court on the 4th of December 1996, then signed into law by the then President Nelson Mandela on the 18th of December 1996. And came into effect from the 4th of February 1997. This final constitution essentially replaced the then effective Interim Constitution. The Interim Constitution was the supreme authority during the transformation process until the new and final constitution was adopted. The Interim Constitution was essentially the fundamental law of South Africa, from the first non-racial general election on the 27th of April 1994, until it was superseded by the final constitution on the 4th of February 1997. The interim constitution also made provision for the establishment of a government of national unity for South Africa during the formal transition process. Furthermore, the interim constitution made, amongst others, the following provisions: to draw up a new and final constitution, to also include all major parties in the elections. The interim constitution also provided for the carrying out of general elections of a new democratic government of national unity, as well as to provide a secure foundation for the people of South Africa in order to transform into a true democratic nation. The interim constitution also provided for working towards peace and reconciliation. Before we continue, here is an interesting fact about the Constitution of South Africa.
I am an African.
This popular speech, which was coined by the then Deputy President, Thabo Mbeki, was made on behalf of the African National Congress in Cape Town on the 8th of May 1996. This event marked the adaptation of the South African Constitution. At the time, Mbeki was the Deputy President of South Africa under the presidency of Nelson Mandela. This is also a good time to welcome you again to our channel. Please make sure that you check out our other videos on public administration under this channel. And don't forget to like this video and subscribe for more content. You can also support the channel by joining our exclusive channel membership community by clicking on the join button below. When you join, you get a number of exclusive benefits, such as early access to our videos, as well as our uploading schedule. You can also suggest new topics we should cover for future videos, and exclusively chat to our creators. Now, let's get back to today's video. In this section, we will discuss the characteristics of the South African Constitution. The preamble of the Constitution states that the Constitution aims to heal the division of the past and creates a society based on democratic values, social justice, and basic human rights. It aims to lay the foundation for a democratic and open society, in which government is based on the will of the people, and every citizen is equally protected by the law. It also aims to improve the quality of life of all citizens, and frees the potential of all people. The South African Constitution further guarantees equal rights for all citizens of South Africa, as well as contains a Bill of Rights that regulates the relationship between state and citizens. The South African Constitution has supremacy over Parliament and makes provision for the formation of a government of national unity. It also entrenches various interests of the community. For example, an electoral system of proportional representation, etc. This new constitution also replaced the previous 4 provinces with the new 9 provinces, with each province having its own provincial government and legislature. Post-1994, the new South African Constitution consists of a preamble, 14 chapters containing 244 sections, as well as 8 schedules. We will now briefly discuss each of these chapters. Firstly, let's discuss the preamble. In the South African Constitution, the preamble announces to the nation and the world that this document is no ordinary piece of legislation. The preamble also lays down the main objectives of the Constitution and contains the values and the ideals which the Constitution aims to achieve. Chapter 1 of the Constitution, on the other hand, enshrines the key national principles. This chapter further defines the country's flag and the national anthem, and further specifies the official languages and the principles of the government language policy. Chapter 2 sets out the Bill of Rights. This is arguably the part of the Constitution that has the greatest impact on people's daily lives. The first words of the chapter states clearly that this Bill of Rights is a cornerstone of democracy in South Africa. This chapter also sets out the fundamental rights of not just South African citizens, but in some respects, the rights of everyone. It further protects individuals against government's violations of their rights, and establishes government's duties towards the people. The Bill of Rights also limits some of the human rights under the Constitution. Although this is not the longest chapter in the Constitution, it is however a crucial part of the Constitution because it protects individuals from abuse of power by the state. Chapter 2 further affirms a number of important rights such as the right to human dignity. This chapter also extensively includes an equality clause, which states that all individuals are equal before the law, and that no one should be unfairly discriminated against on the basis of their race, or gender, or ethnicity, or social origin, as well as sexual orientation. The Freedom Clause, under this chapter, also acknowledges the power of individuals to make choices towards their personal development and fulfillment. Chapter 3 of the Constitution lays down the principles of cooperative government. It states that there is one central government that is divided into 3 spheres, which are the national, the provincial, and the local government. Although each sphere is autonomous, they must still work together. Chapter 4 defines the structure and powers of Parliament, which is the legislative branch of the national government. Parliament is responsible for representing the people and for passing new laws, as well as amending existing laws. Parliament consists of the National Assembly, as well as the National Council of Provinces, commonly referred to as the NCOP. To learn more about the role of Parliament in South Africa, please check out this video under our channel. We will pin the link to this video in the comments section below this video. Now, back to the various chapters of the Constitution. Chapter 5 defines the structure of the national executive and the powers of the president. The national executive consists of the president, the deputy president, and cabinet ministers. It is important to note that the president cannot exercise any power which is not conferred to him or her by law. The exercise of that power must, however, be rational. Under the Constitution, The President is both the head of state and the head of the national executive. The President is often elected at the first sitting of the National Assembly, following the elections, and serves a term of 5 years. In terms of the Constitution, no president is permitted to serve more than 2 terms of the presidency. Chapter 6 defines the powers and structure of the provincial governments. It also sets out the areas over which both the national government and the provincial government may make laws, and further states what happens if these laws contradict each other. This chapter also deals with the drafting of provincial constitutions. Chapter 6 also establishes the 9 provinces of South Africa, which are
the Eastern Cape, the Free State, the Gauteng Province, KwaZulu-Natal, Mpumalanga, the Northern Cape, the Northwest, the Western Cape, as well as the Limpopo Province.
Chapter 7 sets out a framework for local government and municipalities. This chapter describes the status, powers, functions, and the composition of the local government. It also explains the makeup of local government, its powers and functions. The various local governments around the country are responsible for making decisions and laws for their municipal areas. The Municipal Council, which is a body elected under the local government elections, is responsible for carrying out the executive and legislative functions of the local government. Again, if you are interested to learn more about municipalities and how they work, please check out this video under our channel. Now, back to other chapters of the Constitution. Chapter 8 establishes the structure of the judicial system. This chapter also defines the structure and powers of the judiciary, with Section 165 of the Constitution conferring the judicial authority to the courts. Judicial authority empowers the courts to interpret and apply the law when considering legal cases before them. According to the Constitution, the head of the judiciary is the Chief Justice. There are various courts in South Africa, each with a different status, such as the Constitutional Court, the Supreme Court of Appeal, the various provincial high courts, and the various magistrates' courts around the country. Look out for a new video on the various types of courts in South Africa, which we will be posting in the future. Chapter 9 of the Constitution establishes a number of institutions, commissions, and offices, which are tasked with protecting and supporting the constitutional democracy and the human rights of everyone in South Africa. The task of these institutions is to promote and protect those rights within the Bill of Rights, which fall within their particular area. These bodies are autonomous, and other state departments are expressly charged with assisting and protecting these bodies to ensure their independence, impartiality, dignity, and their effectiveness. We have also published another video on these Chapter 9 institutions under our channel. So, if you are interested to learn more about these institutions, please check out this video under our channel. Chapter 10 of the Constitution lists the values and the principles for the administration of the civil service and establishes the Public Service Commission to oversee it. Essentially, this chapter sets out the principles which govern the public administration and the people who are employed by the state. It also sets out the principles, as well as the framework within which the public administration must operate in order to deliver government services to the people. The public service must be structured and function in terms of national legislation, and must effectively and efficiently execute lawful policies of the government. Under this chapter, there is Section 195, which states that the public administration must be governed by the democratic values and principles enshrined in the Constitution. Chapter 11 establishes structures for civilian control, including the police, the army, and the intelligence services. The chapter also states how each of these institutions must work in order to secure the state. This chapter further requires security services to operate in a manner that does not violate fundamental constitutional values and principles. Chapter 12 of the Constitution recognizes the status and authority of traditional leaders and African customary law. The chapter essentially deals with traditional leaders and their role in the democracy of the country. The role and status of traditional leadership, according to customary law, are also recognized. The chapter also allows for the recognition of traditional authorities and for such traditional authorities to function within the framework of the country's legal system. Furthermore, the Constitution establishes a National Council of Traditional Leaders, as well as provincial councils of traditional leaders. These councils allow traditional leaders to play an advisory role in matters relating to traditional leaders, as well as customary laws in the national and the provincial governments. This chapter further recognizes African customary law as part of South African law. The chapter also states that the courts can apply customary law in appropriate cases as long as that customary law is consistent with the Constitution. Chapter 13 deals with public finance. It establishes a national revenue fund, from which money may be appropriated only by an Act of Parliament, as well as the establishment of provincial revenue funds, from which money may only be appropriated by an Act of the provincial legislature. This chapter also gives emphasis to the need for transparency, accountability, and the effective financial management of the economy. Chapter 14, which is the final chapter of the Constitution, deals with transitional and incidental provisions. This chapter contains the general provisions on various matters of the Constitution, such as the Constitution's commencement dates. The chapter also contains specific provisions about international agreements and customary international law, and how each of these apply in South Africa. This chapter further provides that international agreements become binding once they have been signed into law by Parliament, and that customary international law is regarded as law in South Africa unless it flouts the Constitution or an Act of Parliament. In addition, attention is given under this chapter to other matters including the funding of political parties, the official and full legal description of the Constitution, as well as its commencement date. This chapter also provides that, if inconsistencies arise from the translation of the Constitution into the 11 languages, the English version is regarded as authoritative. As previously indicated, there are 7 schedules, which form part of the Constitution. These schedules deal with the national flag, the geographic area of provinces, oaths and affirmations, election procedures, functional areas of concurrent national and provincial legislative competence, functional areas of exclusive provincial legislative competence, transitional arrangements, as well as previous laws repealed by the Constitution. The Constitution provides certain benefits to the people of South Africa. Some of them are as follows. The Constitution aims to heal the divisions of the past and creates a society based on democratic values, social justice, and basic human rights. It further lays the foundation for a democratic and open society in which the government is based on the will of the people, and that every citizen is equally protected by the law. The Constitution also aims to improve the quality of life of all citizens and frees the potential of all people. Furthermore, the Constitution determines the relationship between citizens and the institutions that govern them. Lastly, the Constitution aims to build a united and democratic South Africa, which is able to take its rightful place as a sovereign state in the family of nations around the world. In conclusion, we discuss why the Constitution is so important. South Africa is a constitutional democracy. The Constitution of South Africa is the supreme law in South Africa. This means that the Constitution is the highest law of the land. Therefore, Parliament cannot pass a law which goes against the Constitution. This also means that no person, not even the President of the country, can go against it. The courts and the government must also make sure what they do is constitutional. The Constitution itself is protected because it is much more difficult to change than any other law of the country. Most amendments to the Constitution require a 2/3 majority in the National Assembly alone, and the 6 of the 9 provinces in the National Council of Provinces to agree to that amendment. We've now come to the end of this video on the South African Constitution. So, thank you for watching. Please take time to check out our other videos on public administration and public finance under this channel, where we discuss various topics relating to public administration, public finance, public management, as well as the management of the public sector, including the running of government. Also make sure that you subscribe to our channel. And remember to like this video. And also to leave us a comment below this video. You can also continue the conversation by following us on social media at ConsultKano, or use the hashtag ConsultKano. Until next time, check out this video. Thank you again for watching. Kano Consultants. For professional advice you can trust.